been disqualified, then they would have gone out. The speaker would have, the governor would have then called for a trust vote. With the one change that Shinde would have not been called upon to be the chief minister then. Then the governor would have called upon perhaps.
And my lords, you take it forward. There are
the BJP to form the
there are too many hypothetical assumptions, presumptions on the petitioner's part. So and so would have happened. Thus, this would have happened. Then there's a constitutional saying everything would have been annulled in the process. That's not how.
They are right in to this extent that the request to Shinde to become and to swear in Shinde as a chief minister, and the opportunity given to him to establish his majority on the floor of the House on the 30th came into being only because in the meantime that speaker could not disqualify Shinde, because if he had disqualified him, all the 39 would have gone out. It would have not made a difference. The Shivsena, probably that coalition wouldn't have come back to power. Possibly, because these 39 go out. But with the 39 going out, the composition of the government today would have been entirely different.
Well, as I respectfully submitted, these are
hypothetical.
Too many hypothetical. But all I'm saying is the speaker could not continue with the disqualification.
Not exactly hypotheticals, because you know what was happening and what would have happened.
No, my lords, what I'm saying is that.
So the speaker was acting in post haste. That's why, the writ petition.
The speaker was acting in post haste in every which way. On the same day he approves a new leader. On the same day he says you file your replies within 2 days.
Of course, the 39 would have come to this court and said, well, we have been disqualified without giving us even 7 days notice.
That's why
in which case, stay the order of disqualification, which is contrary to law.
I wanted to point out
one
timeline which is important, which I forgot when I was reading the timeline, and it has some relevance here. On 21st, when the notice to the deputy speaker was sent for removal, on 21st, was sent to the speaker, it was signed by 34 MLAs and it is admitted by the deputy speaker in his apart from removing the 39 or whatever the 3 independents, they were actually running away from actuals. 13 of the people who were supporting them also abstained. 16 abstentions were there. 13 of them were their own people who were supporting them abstained. Came to 99. That is how they came to 99 on that day. Please, my lords.
You're saying something?
My lords, the second page, where if your lordships were to see the first chart, votes against Mr. Eknath Shinde 19. This is a 99. These are, my lords, the 13 people of the 16 who abstained. 24 abstained, 13. 13 were from Agadi, the NCP.
Of the 24 who abstained,
Yes.
13 of the other group.
Yes. So quite apart from the 42 being deleted, your own people were not there to support your government. Nine.
13 from MBA abstained.
Abstain. So your leave aside disqualification. I have even given charts that if you exclude the disqualified members, still we win. But here are people who are supporting you. Even they abstained. Yes. Yes.
I see. I got it, yes.
Now, my lords, just to answer what my lords put to me, my lord, the Chief Justice, to say that Mr. Shinde would not have made it is wrong for the simple reason, my lords, and I say this humility, that A, till he is disqualified, he continues to be a member of the House.
No. What the Honorable Chief Justice says is, if he would have been
but my lords,
disqualified, then
my lord, but as I respectfully
so he was one of the person against whom the disqualified.
But the speaker could not have gone ahead with that disqualification in view of Nabam Rebia. So how do we presume had he been disqualified, then had he been then all?
Not pressed at all.
Yes, my lord.
Argued according to you.
But my lords, I said so, and I've been right through saying from the beginning because I argued. I'm not for a minute suggesting I did not argue Nabam Rebia. I did argue Nabam Rebia.
No, but even if you look at it from on a demurrer,
yes,
that suppose Nabam was not there, the consequence of Nabam not holding the field would be that the speaker would be entitled to decide the disqualification, notwithstanding the pendency of a notice for his own removal.
Right.
If he had decided the disqualification,
right,
then these 39 would have gone out.
Right.
In which case, still the government had to fall.
Absolutely.
On the numbers.
That's why I've given the charts with 42. I consciously made these charts with 42, minus 42, and now I'm going a step further. Mr. Jethmalani rightly pointed out to me, he said that these 13 also, the ones who were supporting them abstained. There were 16 abstentions. So whichever way we look, the numbers were not there. And that's why this chief minister, the then chief minister, resigned within 10 minutes because he knew he did not have the majority. And he was not confident to face the floor.
Because he was aware that
he was aware what was happening. So everything we go back to say that because of disqualification, this was fait accompli. You can't even take care of people who were supporting you, the 13.
So far as Nabam Rebia is correct, the order dated 27/6. You might have pressed Nabam Rebia. At that time, you might have argued also. And you, according to you, argued also. But this court, correct, did not injunct speaker, correct? Maybe technically till 12th, correct? He was restrained from, it can be said he was restrained. But there was no restraint at all, correct? Against the speaker exercising the powers.
I bow down to it.
If the Nabam Rebia would have been considered by this court, then
he could not have continued.
Then
no proceeding should have been stayed before him. My lords, I said so repeatedly, the entire argument was heard. Ultimately, the court Considering because the same argument made, there are problems, Nabam Rabia applies, doesn't apply. The court said only on pure principles of natural justice give them more time because the rules provide for 7 days. And on a weekend, you've given them 2 days. So there was say that your lordship's order was the result. And then your lordships are told because of that, rewind everything.
So fast. That is why it is.
In fact, Manoj, that's why in para 78, your lordships say of Shivraj Singh Chauhan, timing on a particular date, what happens, in whose favor, what tilts, that's politics. And they say that's none of the concern of the court. The court, that's what your lordships records in para 78 of Shivraj Singh Chauhan. Yes, fine. With this, but another argument which was made was that even in our notice to the speaker, we had not mentioned anything about majority. There's a specific paragraph in the letter to the deputy speaker that he has lost the majority. So to say that we had not mentioned it is factually incorrect. And as far as notice to the speaker is concerned, my lord, that's the last point before I go to the case law. 21st, I give a notice. The deputy speaker files an affidavit in this court that notice was received. Secondly, on 22nd of June, a hand-delivered copy is given. An email is sent to which apparently the speaker comes, and that day Dr. Dhawan appeared. He appeared in court and said that to this, it was not from an authorized email. So we pointed out that there is Rule 18 of the Maharashtra Legislative Assembly rules, which just talks about a signed notice being given. There's no other restriction on it. So even if we exclude the 24th, 21st we send, the deputy speaker accepts that such a notice was given. 22nd, a hand-delivered copy is given with a stamp, which we showed to the court when we went. So he said, what are you talking about not receiving a copy? This is a hand-delivered with a stamp. And on 23rd is the disqualification petition. And that is why, my lords, I said the scope for misuse of disqualification is enormous, and that is exactly what was sought to be done. You knew there was discontent. You knew it was simmering. You knew it reached its culmination on 21st with a resolution being passed at the meeting that overwhelmingly the cadres were not happy with this coalition, and you knew that the next sequitur to this will be a trust vote. You immediately move a disqualification petition, and the speaker on the very same day accepts your person, and then 2 days later I am told file a reply. It's under those circumstances that I came, because repeatedly your lordships are told constitutional propriety, morality, abuse. If at all there has been abuse in this matter, my lords, it has been by the regime then in power and the then deputy speaker, with the hurry that they moved, that they did not even follow the basic norms of natural justice. If the 7 days were required, what was the hurry in giving 2 days? And the only argument the other side had was that in one of the matters your lordships have held that even 2 days was enough. So I'll also cite 5 judgments to say that 2 days were not enough. Where your lordships have said there's no straitjacket formula, it has to be seen in the facts of every case. That takes us nowhere. But given the facts, what was this great hurry that over a weekend you wanted replies to be filed? That's what led to our 32 being filed. Quite apart from the fact that Quixote was not a bar to us, because Quixote works if you're seized of a matter, speaker is seized of the matter, you don't go to court. Not in a case where Nabam applies, that the speaker has a disqualification pending against him, removal pending against him, and he cannot proceed at all. It was in those circumstances that I came by way of a 32. Now, my lords, I'll come to the case law.
Case law on the point.
Yes, my lords. distinguishing Mayawati's judgment.
Cite the judgments in chronological order and then distinguish whatever they have cited along the way, so that perhaps you can do that in a chronological order. Whichever judgments you are citing, you can cite them chronologically, and then if they have relied on a particular judgment, you can distinguish it along the way. That's one way of doing it. Or you can cite Mayawati.
I thought, my lord, there are 4 or 5 crucial judgments that they relied on for their case.
All right,
and then I'll come to my
all right,
own.
fair enough. And then you can cite your judgment.
Yes.
Judgment compilation volume.
Well, in fact, if your lordships permit, I'll just very briefly tell your lordships of the facts. I won't bother your lordships with the paras at all. I'll give the facts. I've summed up the facts.
Just give us the reference in the compilation, that's all. So if you have to...
Convenience compilation volume 2. PDF page 1080.
Citation.
1998.
1998 volume 7 SCC 517. In 1996, my lords, in the general elections to the UP Legislative Assembly, no political party obtained an absolute majority case. So there was an agreement between the Bharatiya Janata Party and the Bahujan Samaj Party. BSP at that stage had 67 MLAs and the BJP had 175 members in its fold. On 21/9/1997, Mr. Kalyan Singh of the BJP was sworn in as the Chief Minister. On 19/10/1997, the appellant, that is Avati, announced withdrawal of participation and support of the BSP to the coalition government. All the BSP members resigned from the government. Immediately, the governor of the state convened a special session of the assembly at 11 a.m. on 21/10/97, that date is important, and told Mr. Kalyan Singh to prove his majority on the floor of the house. After that, on 28/10/97, appellant issued a whip directing all BSP MLAs to remain present in the house throughout the proceedings on the next date and vote against the motion. That was the whip issued. On 21/10/97, 222 members of the assembly voted in favor of the government. There was no vote opposing it. On 24/10/97, 13 petitions were filed seeking disqualification of those members of the BSP. On 20/10/97, the whip which had been given. And the petitions invoked only clause 2(1)(b) of the 10th schedule. Your lordships may note that. The allegation was 2(1)(b) of the constitution. On 25/11/97, the concerned MLAs against whom disqualification petitions had been filed their written statements and pleaded that a split took place between the members of the BSP on 21/10/97, and more than 1/3 legislators of the BSP got separated, and thus they relied on the protection of para 3 of the 10th schedule. The 398 dismissed the disqualification petitions and recognized the MLAs as a separate political party. In this background is what the appellant said, and in this background what the appellant said is that it is the whip which is issued by the erstwhile legislature party of the BSP and not the new political party which had been formed, as used in para 2(1)(d), is the legislature party of the original political party of those MLAs is what has to be read into 2(1)(b). The court said nothing doing. Political party, as mentioned there in 2(1)(b), cannot be read as a legislature party. So this was a split, a new party had been formed and they were bound by the directions of the new party and protected by that.
What were they relying upon in Mayawati in particular? What is the...
That a whip of the legislature party of the BSP of which they were a member, before splitting,
That is
had told them not to vote.
28th October whip.
Yes, had told them not to vote in favor of the motion.
Right.
So they said you violated the whip of the legislature party. And because you violated the whip of the legislature party, you are disqualified. They said we have split and we formed a new party. And our new original political party told us what to do. We did it in compliance with that. So Ms. Mayawati argued that you read legislature party into 21B and that whip ought to be obeyed of the old party. The court said, no, we will read it as the political party and they are protected by para 3 of the 10th schedule. Now, my lords, in our case, there is no rival faction which has split. The rival faction is within the party. No new political party has been formed. The question is not of an erstwhile legislature party of a party that you belong to vis-a-vis the new original political party that you formed. Point says that when interacts with the whip as appointed as per the rules conveyed by the leader, etc., should be ignored and we should look at some deeper other whip which the political party is appointed. That's not what it says. All it says is, in the given facts and circumstances, that legislature whip of the party is not applicable because they are protected by the sanction as given. By the formation of the new political party. So Mayawati, according to us, my lords, has no application at all. And in any case, my lords, as I have said, it's never been our case that it's only the legislature party and not the political party. We've right through said both are co-joined, organic, integrated, and any action of the legislature party has the political authority of the political party to say what it says. Volume 1, PDF page 834. So, my lords, Rana is relied on by them. I relied for a different purpose. They rely on Rana for two essential purposes. One is that it said disqualification is ex post facto. So, everything goes back to the date of disqualification. In an appropriate case, decided the issue of disqualification as a court of first instance rather than remanding the matter or letting the speaker decide. Those are the two grounds taken to rely on Rana. Now, my lords, just some facts. Quite apart from the second issue, my lords, the straight answer would be the matter was pending for 3 years in the High Court. The High Court then remanded it back. The Supreme Court said the assembly elections are at the end of the year. Rather than remanded, decide the matter. Those are peculiar facts, not that in every case you bypass the constitutional authority and come to the Supreme Court as a court of first instance. But on the first part, my lords, some crucial facts. UP elections, my lords, to the UP State Assembly, a coalition government was formed headed by the Bahujan Samaj Party. In 2003, my lords, the cabinet recommended dissolution of the assembly. And now this is important. Before the resignation of the cabinet, my lords, on 27/8/2003, 13 MLAs of the BSP party met the governor and requested him to invite the leader of the Samajwadi party to form the government, the opposition to form the government. The governor acceded to the request. And thereafter, Mr. Swami Prasad Maurya, who was with the BSP, filed a disqualification petition saying that they had voluntarily given up the membership of the party by supporting Samajwadi Party and going to the governor. 13 members, those 13 MLAs who had gone to the governor with the Samajwadi Party MLAs, fortified by another 24 MLAs, requested the speaker to recognize a split in the party, and the speaker recognized the split in the party. The Supreme Court said that split and to be entitled to the benefits and protection of para 3 of the 10th schedule is an event which happened later. The governor is only concerned with the day when those 13 BSP MLAs met the governor and requested of the Samajwadi Party to form the government. And the speaker should have only looked at the facts on that day and said not at subsequent events, and in that context said, ex post facto, it will go back to the day they were disqualified or incurred disqualification under the 10th schedule. It could have never been the intent of the court, and it did not say so, that on one hand the Supreme Court says that till disqualifications petitions are pending, you participate in all proceedings. On the other hand, the moment you are disqualified, all your actions are annulled. So ex post facto was specific because the speaker started looking at subsequent events. The speaker started looking at a split which had not happened on that day. And they said this is an overt 2-1A act, where you go to the governor, request him to get the Samajwadi Party to form the government. It was in that context. The other part of Rajendra Rana, I pointed out to my lords that, now my lords, another judgment.
Morning, just give us in 2 pages a small note on how you distinguish each of those judgments.
Very well. No, I'll do that. I'll get for all those 4 or 5 judgments.
That's right.
A distinguishing note tomorrow.
Just 2 or 3 pages.
Yes.
There's a bullet.
And what I'll do, my lords, tomorrow is I have also prepared a written note of the various propositions and judgments that I'm relying on.
Right.
I'm in the process. I'll take your lordships through that, and wherever your lordships wants me to really read any particular paragraph, I can do that.
All right. That will be much quicker then. Yes.
If
Faster.
just
Now,
to
just so that you know, how long would you take? Will you finish in about an hour or so tomorrow?
yes,
So we target starting by 11 o'clock tomorrow. So 12 if you finish, then between Mr. Jethlani,
What I am respectfully submitting
if you can, Mr. Jethlani and Mr. Maninder Singh, if you can give us a brief note of a page or so.
I was about to say that, Malad, to remain within the time discipline, Malad, we'll furnish a note by today evening. And Malad, very 10-15 minutes, Malad, we'll just make your lot.
If both of you can just give us, email the note to the court master, so he'll circulate it in the night to us and give it to Mr. Sibal, because Mr. Sibal will also be then.
Try to finish before.
And you can also email
The
your note to
problem
Mr.
is the
Sibal.
Solicitor General is to argue. Please remember that.
Yes, of course.
So-
Now, what about the solicitor? So maybe, Mr. Kaul, is it possible for you to sort of complete by say quarter to 12? Say we start at 11 because we have mentioning. You can try and compress it by quarter to 12. Then between Mr. Jethlani and Mr. Maninder Singh by 12:15, that leaves 45 minutes to the Solicitor General. If we can do that, we entirely with.
We'll try our best, as succinct as we possibly can be, we'll try.
Because otherwise
that-
it will be
Right.
difficult.
otherwise the rejoinder could
difficult
be
for us.
restricted to 1 hour. They've argued for 3.5
Otherwise
hours.
it will be difficult. So if they don't finish by 1 o'clock.
Rejoinder already depends upon how the other side is.
Then one and-
What the other side is.
So how long was the solicitor likely to take? Any idea?
He said 1 to 1.5 hours to me.
So
1 to 1.5 hours to me, he told.
All right, try and make your arguments as compared. But we'll wrap up with this side by lunch so that, yes.
kind of us will sit down.
No, it's
Within
not
the
like that.
time-
We just,
The one
because,
thing-
only because we are heading
the
towards
one
a
thing-
week-long break, and we don't want to keep this beyond the break. That's the
The one thing the learned Chief Justice is he never gets tired of anybody. He never shows it at least.
That's the theory of it.
No, but that's a fact in my mind as well, because,
I know.
if you have an understanding about how vast the field of knowledge is, you can never tire of
That's
the
the-
arguments which lawyers wage before.
We've
Because
noticed
the last word is never said until the last word is over.
That's correct, that's correct. And I hope we have.
Very grateful, man. Very grateful.